Good morning. As you can see from the extracts of my oral presentation that you have in Czech language, I have slightly changed the title. So my title is Basic Conditions for the Rule of Law in Asylum-Related Detention Cases, from Magna Carta Libertatum to the Judicial Checklist of the European Law Institute. Let me first share with you my intimate concerns that I have had when I started to consider which particular subject of detention I should pick up for the 30-minute speech. No doubt, rules on detention represent a vast and detailed area of law where secondary and primary EU law, case law of the Luxembourg Court, case law of the Strasbourg Court, and national laws set a complex and complicated legal framework. So it is definitely not an easy task to respect the basic requirements of the rule of law in this field. On the other hand, my concerns were influenced by personal experiences and professional contacts I have had in the past with some colleagues from the Czech Republic, with judges like Jakub Samrda, Zdeněk Kun, with critical academics, David Kosar, Michal Bobek, before he became an advocate general, and with Hanna Lupacheva. What could I meaningfully add to the high quality discussion I'm sure you already have within the judicial and academic circles in the Czech Republic? Detention cases such as Arslan and Al-Shodor prove that. Furthermore, according to the results of the recent empirical study of researchers from the University of Copenhagen, the Czech Republic ranks almost on the top of the scale of the compliance rates of the 47 contracting states as regards execution of judgments of the Strasbourg Court. Slovenia is behind the Czech Republic and holds the 9th position. However, I know from my experiences in Slovenia that a high compliance rate of execution of judgments against Slovenia does not tell much about the effective implementation of overall standards of the case law of the Strasbourg Court in our jurisprudence. The relevant question is whether Slovenian judicial authorities established a system, information system, where we can follow the developments in the Strasbourg and Luxembourg case law, where the Slovenian courts engage in the learning processes and in judicial dialogue with both European courts through our concrete judgments in order to prevent future violations, to improve the quality of adjudication, and to preserve the rule of law. There are certainly some similarities between Czech and Slovenian legal culture, but I will use this comparison only as an excuse that I will share with you for this occasion 3 elements that I would share also with my Slovenian colleagues at a similar hypothetical occasion in Slovenia. And in my presentation, I will also raise your attention to some points where you can find the same line of arguments for the rule of law from the yesterday's presentations. Before I get to those 3 elements, I take as a starting point the aforementioned fact that detention cases are not easy disputes, and that evaluation of judicial control of detention from the standpoint of respect of European standards may be used as one of the relevant indicators for the compliance with the rule of law. And I would like to stress a few turning points in this regard from a historical perspective. The Western civilization made a huge legal development starting from the beginning of 13th century with Magna Carta Libertatum until the adoption of the Return Directive Reception Directive and Dublin Regulation in 2013, followed by judgments of the Luxembourg Court and, of course, the case law on detention of the Strasbourg Court, which started 25 years ago with the case Amour versus France. The principle of habeas corpus from Magna Carta Libertatum constitutes one of the earliest expressions of the rule of law. It acknowledged that everyone, including the king, is subject to the law. You have the text of habeas corpus under point 1 of my extracts. One can find a direct influence of habeas corpus tradition in the Return Directive, where the EU legislator, only in relation to detention order, regulated the right to effective legal remedy to be provided by an independent and impartial court, while for the return decision, a legal remedy may be provided by independent authority and not necessarily by a court. Then there is a judgment of the United States Supreme Court in case of Fred Korematsu. This judgment was delivered during the wartime between the United States and Japan, when President Franklin Roosevelt issued executive order which authorized the removal of citizens of the United States of Japanese ethnic origin from West Coast from their homes and their mandatory imprisonment in camps. Mr. Korematsu thought this was a discriminatory detention, and the Supreme Court decided that even during the war between the United States and Japan, restrictions which curtail the civil rights of a single racial group must be subject to the most rigid scrutiny. Please remember this test of most rigid scrutiny in detention cases. After the terrorist attacks in early 21st century, a similar case as the Korematsu case came to the Supreme Court of the United Kingdom. The UK government tried to introduce a derogation from the obligation to protect the right to personal freedom from Article 5 of the European Convention, but only for non-UK nationals. In the proceedings before the Supreme Court, the Attorney General argued that it is for the Parliament and for the Executive to assess the threat facing the nation, and that this is not a competence of the courts at all, because in his views, those were matters of a political character. Justice Bingham responded to the argument of the Attorney General by saying the following, and I quote, "I do not in particular accept the distinction which the Attorney General drew between democratic institutions and the courts. It is of course true that judges in this country are not elected and are not answerable to the Parliament, but function of independent judges charged to interpret and apply the law is universally recognized as a cardinal feature of the modern democratic state, a cornerstone of the rule of law." End of quotation. Thus, the Supreme Court declared relevant sections of Anti-Terrorism, Crime and Security Act as incompatible with Article 5 and 14 of the European Convention. The court decided the government did not prove that derogation from fundamental rights would be strictly necessary. Justice Bingham, therefore, used a similar judicial test as the Supreme Court in the United States case Korematsu. In fact, he actually referred to the Korematsu judgment from 1944. Under point 4 of my extracts, I have put 3 examples of significant expressions of separation of powers and judicial independence in the period just before the mass influx of refugees in Europe at the end of 2015 in the field of detention. Federal High Court of Germany and High Administrative Court of Austria decided that there is no legal basis for detention under the Dublin Regulation if alleged risk of absconding is not properly defined by objective criteria in national law. The Court of Appeal of England and Wales in July 2015 declared fast-track rules which established the mandatory detention of asylum seekers as systematically unfair and unjust. Today, the judicial approach to the most rigid scrutiny test, or to the test of strict necessity in detention cases, is reflected in the case law of the Luxembourg Court and of the Strasbourg Court. Under point 5 of my extract, I have selected for these occasions 7 component parts of this judicial control of detention cases. This follows the line that was started yesterday by Hugo Story about independent and effective judicial protection in asylum disputes, and by Jacek Klebny in disputes on refusal of visa. Of course, these 7 selected component parts of judicial scrutiny test presuppose that the applicant has an effective access to court, that is, habeas corpus. Perhaps it is worth to stress that, with the exception of the Mahdi case, the Luxembourg and the Strasbourg Court developed these standards after the mass influx of refugees that we experienced at the end of 2015. Let me now present the 3 core elements of my today's presentation. The first element will be my personal observation on the reasons why there is such a discrepancy in Europe between what is in the European law, in the case law of the Strasbourg Court and in the case law of the Luxembourg Court, and what is going on in practice. This includes detention of vulnerable applicants. I ground these observations on my experiences as being a judge of administrative court dealing with detention cases for about 17 years, and on my 20 years of experiences in international legal community. I agree with the federal judge from the United States, Richard Posner, who said in his book entitled How Judges Think, that judges are not moral or intellectual giants, prophets, oracles, mouthpieces, or calculating machines. They are all too human workers, responding as other workers do to the conditions of the labor market in which they work. Namely, as a judge, I must have institutional conditions to work independently and professionally. I have to have sufficient incentives to apply effectively European rules and standards in the field of detention. My claim for conditions to work independently and professionally does not mean that I'm not accountable to the public, but it is of crucial importance in what manner my public accountability is legally framed and exercised in practice by authorities, not just by non-judicial authorities, but particularly by judicial authorities. Under extract number 6, I have listed several basic conditions or institutional factors that must be constantly monitored and sensitively managed in practice by judicial actors if we want to preserve the rule of law in the field of protection of the fundamental rights of individuals' freedom and security, including protection against inhuman treatment in detention cases. I put some concrete judicial references in these regards, which comes from the Strasbourg case law, but also based on the preliminary references of our colleagues from Hungary and Poland. At the moment, more than 10 similar cases on judicial independence are pending before the Luxembourg Court that have been sent by our colleagues from Romania. Today, for example, it happens that a judge is dismissed from her office because she managed to conclude only 85% of her workload, which has been assigned to her for a particular year based on a bureaucratic calculation, although all her judgment in the respective period have been confirmed in appeal procedure. In Slovenia, we have a very vague and broad provision in law, which says that the president of the court may be dismissed if he or she does not perform his duties of administration of justice in line with regulations. These broad provisions can be easily abused. One cannot expect that a judge will take human rights seriously from the case law of the Luxembourg and the Strasbourg court if he or she will be awarded solely for the speediness of his or her adjudication and for the number of cases confirmed by the appeal court. This is too simple, too little, and absolutely wrong from the standpoint of the quality management and judiciary. We judges do not produce plastic slippers. I'm now at point 8 of my extracts. On which aspects of adjudication in detention cases the aforementioned institutional factors have the major impact? Based on my experiences, those institutional factors have the most significant influence on the following aspects of judicial control in detention cases. The question whether detention means a deprivation of liberty or merely a restriction of freedom of movement. A lack of distinction between assessing the risk of absconding through objective criteria and the requirement of individual assessment. Respect of the best interest of the child. Let me stop here for the moment because yesterday we discussed the powers of this article on the best interest of the child, whether Article 24, paragraph 2 of the Charter is a right or a principle, and whether the best interest of the child under Article 8 of the European Convention may lead to the obligation to issue a residence permit. Certainly, under the EU law, the best interest of the child can lead to the obligation to issue a residence permit. We have a proof for this in a recent judgment of the Luxembourg Court from March 11, 2021, MA, which relates to the return directive. And another proof is the Grand Chamber judgment in the case of SM from March 2019, which relates to the Citizens Directive. So what are the following weak aspects in the adjudication on detention? Consideration of the effectiveness of the less coercive alternative measure to detention. Principle of proportionality. Length of detention and due diligence requirement. The right to be informed promptly and adequately about the reasons for detention and about the procedures laid down in national law for challenging detention order. The right to effective access to free legal aid and representation. The right to be released immediately in cases of unlawful detention. The right to compensation in case of unlawful detention. In some states, the problematic aspect is also the threshold for the inhuman and degrading treatment in detention centers. Thus, I come to the second element of my presentation. Facing with the huge discrepancies between what is in the European law on one side and what is going on in practice on the other side, and being aware of what international legal community can do about this discrepancy, a group of judges, experts, and academics from the European Law Institute gathered together in early 2015 to start a project on developing checklists for judges in the field of detention of asylum seekers and illegally staying third country nationals. The European Law Institute is a big network of around 1,500 members, judges, academics, lawyers, and notaries. The European Law Institute has 23 Supreme Courts or constitutional courts as institutional members, including the Court of Justice of the European Union and the Supreme Court of the Czech Republic. It's also an institutional member. I'm now at point 9 of my extract. The idea of the project of the European Law Institute was to develop checklists for the use of judges so that judges could easily and quickly find all relevant references to the case law of the Luxembourg and the Strasbourg Court for as many as possible legal questions in disputes on detention under Return Directive, Reception Directive, and Dublin III regulation. The project team worked for 2 years, and in September 2017, the ELI statement on all 3 checklists was published. Some standards in the checklist are accompanied with explanatory notes, but everything is based solely on the provisions of secondary and primary EU law, referenced with the interpretations and standards from the case law of the Luxembourg and the Strasbourg Court, with indications of exact paragraphs in those judgments. No other sources have been used. Checklists are ready to use by national judges together with the respective national law. Every checklist has around 40 basic standards, criteria, or rules. This includes conditions of detention for particular vulnerable groups. In the section 3 of the ELI statement, we also explain the relations between EU law, European Convention of Human Rights, and national law from all 3 perspectives. Thus, section 3 of the ELI statement is, in methodological terms, applicable for all sorts of disputes when judges implement EU law and not just in detention cases. The publication of ELI checklist is freely available on the website of the European Law Institute. Thus, I come to the last element of my presentation. I would like to highlight and comment recent developments in the case law of the Strasbourg Court and the Luxembourg Court, where both European courts introduced something new, which did not exist in time when ELI checklists have been published. This concerns the use of the concept of freedom of choice of the alleged victims of human rights violations. And this can be linked to our discussion after yesterday's presentation of Hanna Lupachova on the cases of Mboch and CK and others, and the interplay with the judgment of in the case of Papuashvili. Namely, governments are very innovative in trying to diminish the impact of international human rights law in respect of the protection of state sovereignty and executive policy, executive policies, even by trying to make protection against inhuman treatment relative, not absolute. But let me stay with the subject of detention. Before November 2019, the Strasbourg Court held a position that the right to liberty is too important in a democratic society for a person to lose the benefit of the protection for the single reason that the applicant may have given somehow a consent to be taken into detention. Well, this has been changed. Under point 11 of my extract, you have 6 elements of the concept of freedom of choice used by the Strasbourg Court in the case of Ilyas and Ahmed versus Hungary. The idea behind the concept of choice is that if state authorities have undertaken vis-à-vis the individual no other steps than reaction to his or her wish to enter in order to ask for asylum, by carrying out necessary verifications of his or her right to enter the state territory, then this cannot be considered as deprivation of liberty, as long as the applicant's stay in the transit zone does not exceed significantly the time needed for the examination of asylum request. Here we can recall yesterday's emphasis of nulla mole on Article 1 of the European Convention, that conventional rights, this includes personal freedom, are addressed to all individuals under the jurisdiction of the contracting state. In Ilyas and Ahmed, the Strasbourg Court used the arguments that the applicants entered freely in the Rotske transit zone in Hungary and had a chance to leave voluntarily Hungary in direction of Serbia. Thus, it decided that Article 5 of the European Convention is not applicable. There are 2 weak points in those arguments of the Strasbourg Court. The first weak point is that in the very same case, the Strasbourg Court decided that the Hungarian authorities failed to discharge their procedural obligation under Article 3 of the European Convention. Therefore, the court found violation of the right to prohibition of inhuman treatment in its procedural dimension, because Hungarian authorities did not make a thorough and adequate examination of the available general information concerning the risk of the applicant's automatic chain removal from Serbia to North Macedonia and to Greece without effective access to asylum procedure. This link between violation of procedural dimension under Article 3 and Article 5 of the European Convention was not enough for the Strasbourg Court to say that Article 5 is applicable. The second weak point is that under case law of the Strasbourg Court, legal grounds for detention must be clear, precise, and strictly applied. The problem is that the Strasbourg Court did not take into account that under the Reception Directive, Hungary is not allowed to place a person in detention on the sole reason that he or she is an asylum seeker. Nuala Moore yesterday pointed out that according to Article 53 of the European Convention, the contracting state must respect their own national law at first place. Well, the good thing is that in examining applicability of Article 5, the Strasbourg Court used the expression the strict necessity test. And Nuala also expressly pointed out the importance of the necessity in relation to Article 8 of the European Convention of Human Rights. On the same day, the Grand Chamber of the Strasbourg Court also issued a judgment in the case of Z and others versus Russia, which concerns detention of asylum seekers in the transit zone of the Sheremetyevo airport. In this case, the Strasbourg Court decided that Article 5 is applicable because applicants had no practical possibility of leaving the airport zone. Again, The positive aspect is that the Strasbourg Court used the rigorous scrutiny test in examining whether the right from Article 5 has been infringed. Most likely in the case of FMS and others, the Luxembourg Court was inspired by the Strasbourg Court in using the concept of choice, although the Luxembourg Court reached the opposite conclusion as the Strasbourg Court concerning detention in the Rocke transit zone in Hungary. The Luxembourg Court decided that holding applicants in the Rocke transit zone means deprivation of liberty. And you have the main arguments of the Luxembourg Court under point 13 of my extract. One could conclude from the judgment of the Luxembourg Court that the reason for a different conclusion is perhaps in facts, not in law, since the Luxembourg Court established that the applicants could not leave the transit zone voluntarily. Unfortunately, the Luxembourg Court did not use the argument that is explicitly regulated in the reception and also in the Dublin regulation, that a person cannot be placed in detention for the sole reason that he or she is an asylum seeker. After the case of FMS and others, the Strasbourg Court in March this year, in a formation of a small chamber, decided another case related to detention in Rocke transit zone in Hungary. The applicant was a pregnant mother with small children. The Strasbourg Court found violation of Article 3 of the European Convention. In relation to Article 5, the concept of personal choice was used by the court. But this time, the Strasbourg Court found violation of the right to personal freedom. I must stress that it is not that the concept of choice was introduced by the Strasbourg Court only in the field of refugee law. Already in 2017, this concept was used in relation to protection of peaceful enjoyment of possession. But extract number 15, that's the last extract of my presentation, shows examples where the Luxembourg Court used the concept of a choice also in relation to absolute protection of inhuman treatment in asylum-related cases, and this could be problematic. As for the conclusion, I will go back to the Korematsu case. I said in the beginning that in the Korematsu case, the Supreme Court decided that even during the war, at the time of war, restrictions which curtail the civil rights of a single racial group must be subject to the most rigid scrutiny. The wording of the judicial test in Korematsu case was good, but its actual exercise in the judgment was doubtful. The outcome of the case was not favorable for Mr. Korematsu. The Supreme Court of the United States in that case decided by the majority of 6-3 that the presidential executive order on detention was not discriminatory towards citizens of Japanese ethnic origin. Former Justice of the Supreme Court of the United States, Antonin Scalia, commented the judgment in Korematsu case during his lecture at the University of Hawaii in 2014. He said the following, I quote, "The Korematsu judgment was wrong, but you are kidding yourself if you think it won't happen again." I thank you very much for your attention. I'll be happy in trying to answer any question whatsoever you might have in relation to detention, even if it is not directly related to the subject of my speech.